Hello students and welcome to the lecture. So students, as you can see here, that basically in this lecture we are going to start with the judicial review and the activism concept of public, and this is we are going to talk about the part 2. Like in the previous lecture, basically whatever we have discussed about the same topic in the part 1, in which we have seen the various aspects of judicial review and the judicial activism. Now, in this lecture, we are going to continue with some more concepts that are related with the same thing. Okay. Basically, in this lecture, all this is the index that consisting the topic we are going to discuss here. Okay. Like the first is justification for the judicial activism, in which we will see Dr. B.L. Vadera's approach, Subhash Kashyap approach, and Dr. Vandana's approach. Thereafter, apprehension surrounding the judicial activism. We are going to see this. In this, we will see the Upender Bakshi, what is his views and all. Then we will have a discussion over the judicial restraint, in which we will discuss the introduction part and the key aspects. Thereafter, we will have a discussion over the trends in judicial restraint. In this, we will discuss SR Bombay versus Union of India, 1994. Almitra H. Patel versus Union of India, 1993. Then we will have a discussion over the judicial overreach, in which we will discuss the introduction part and the impact of judicial overreach. Then we will have a discussion over the public interest litigation. In this, we will discuss the introduction part, public interest litigation in India, features, scope, rejection of petitions, principles, and the guidelines of admitting the public interest litigation. And at last, we will have a discussion over the summary part. Okay. So this is going to be the framework of the discussion of the topics that we are going to discuss over here. But as usual, before starting the topics for discussion, there is a small disclaimer for all of us. And the disclaimer is like, the images used in a slide deck are for educational purposes only. We respect the intellectual property rights of the original creators and the owners of these images. If you are the owner of any of the images used in this deck and have any concerns or issues, please contact us at sathee@iitk.ac.in and we shall remove the images. Okay. Now let's first begin with the justification for judicial activism. This is by Dr. B.L. Vadera. So if we talk about this, then we can say Dr. B.L. Vadera outlines the several reasons that are to justify the judicial activism. First is collapse of responsible government. It means when the legislature and executives, that are the important branches of the government, they fail to perform their functions effectively, generally it undermines the confidence in both the constitution as well as the democracy of the country. In such scenarios, the judiciary must or may step in to restore the faith and ensure that the democratic processes are upheld. Okay. Thereafter, the citizens' dependency on the judiciary. So we can say the citizens often turn to the judiciary for the protection of their rights and their freedoms, particularly when the other branches like the executive and the legislative branch of the government, they fall short in order to do this. This reliance that places significant pressure on the judiciary so that judiciary should intervene and addresses the issues that are affecting the public. Thereafter, judicial enthusiasm. Judges may actively engage in social reforms and must adapt to changing of times. This proactive stance basically encourages the public interest litigation, or in short PIL, and a broader interpretation of standing basically allowing more people to seek judicial remedies in their aspects. Thereafter comes the legislative vacuum. So we can say there may be gaps in the legislation, like there is no law exists to addressing the emerging social needs. Like we can say, suppose there is a condition when some urgent social needs have been arised, and basically there is no law existing in the country on that time through which we could addresses these social needs. And the legislature as well as the executive branch of the government is not in a way to address this. Basically, this is what we called as a gap in the legislation. And when there is this, then we can say, in such cases, the judiciary may need to step in so that these gaps could be filled through some judicial legislation so that these address to the challenges could be achieved or could be realized. Got it? After this, the constitutional provisions. So we can say the Indian Constitution contains the several positions that enable the judiciary to take an active role in interpreting and enforcing the laws, thereby supporting the concept of judicial activism. It means that basically Dr. B.L. Adhira was supporting the provision that the judiciary is not only intervening in the matters on extra constitutional ways. It means they are using their constitutional ways and they are containing their constitutional provisions so that the judiciary could be unable to take an active role, and that's why they having the power to interpret and influence the laws as well. Thereby they are supporting the concept of judicial activism. All right. After Dr. B.L. Abhidhira, now we have the justification that was given by Subhash Kashyap. So Subhash Kashyap generally identifies the additional situations where the judicial intervention may be necessary. The first such condition was legislative failures. It means that when the legislature fails to fulfill its responsibilities, in such condition, the judiciary may need to intervene so that they could essential the fundamental principles or the fact. Second is weak government. What does it imply? Like in the cases where there is an hung legislation. Hung legislation means that the legislature is not in a position they could pass a law and they are weak and even the government is unstable. It means the party that has formulated a government in the parliament, that political party is not having that much of majority so that they could ensure the passing of the bill without any further requirement and justifications. Then in such occasion, we can say that the government is not willing to take any step that could hamper their situation in the parliament. Doesn't matter whether this avoidance of taking step is affecting the rights of the citizen or not. Okay. It means that whenever there is a weak or the unstable government, it will always be unable to make the decisive policies. In such a condition, when there is a gap because of this hung legislation, the judiciary might step in and to provide the necessary guidance or intervention and even the actions so that the protections could be given and protections could be provided. Thereafter, the fear of decision making. Like we can say, political leaders, just because supporting the majority and supporting their political image, they may avoid making that difficult decision out of fear of losing power. In such cases, they might pass continuous issues to the courts so that they could delay the decision making or shift their responsibility. Because they will just say the matter is in the court and whether will be passed, then we will take an action over this. This is also a matter when the judiciary could intervene. Alright. Thereafter, Fourth one is failure to protect the basic rights. Like if the legislature and the executive, they do not protect the fundamental rights such as decent standard of living, healthy environment, or the concept of fair governance. In such a cases, the judiciary may intervene to uphold these rights. Alright? Thereafter, the misuse of judicial process might be there could be the conditions like during the periods of political turmoil, such as the emergency and all. The strong parliamentary governments may issue the judiciary for their ulterior motive. And then the judicial activism should be there so that they could counteract such abuses and all. Thereafter, the court's populist tendencies. Occasionally, the courts may fail prey to populism, media influence, or a desire to getting the publicity, which could lead to the questioning of judicial decision. So in such a cases also, the judicial activism could be there so that these cases could be affected handily. Thereafter, now we have the justification for the judicial activism, and that is given by Dr. Vandana. So Dr. Vandana highlights the following trends that reflecting the judicial activism. The first is expansion of hearing rights, like increasing opportunities for public participation in some administrative processes. First thing. Second is excessive delegation, criticizing the delegation of authority without the sufficient limits. Thereafter, the judicial control over the discretionary power, like extending the judicial oversight over some discretionary powers that are generally exercised by the administrative bodies. Okay. Then, the broadened judicial review, expanding the scope of judicial review to include a wider range of administrative actions and all. Then, promotion of the open government, advocating for the transparency and the accountability in some government operations so that the judiciary could come in and take the charge. Contempt of power, the potential misuse or overuse of the contempt of powers by the courts that could be checked when the courts are actively participating in their own areas. Thereafter, exercise of non-existent jurisdiction, like the courts acting beyond their jurisdictional reports could be there. Then overextension of interpretation, extending the rules of legal interpretation to achieve the broader economic, social, and educational goals as well. Thereafter, unworkable orders, like issuing the orders that are impractical or difficult to implement. These orders could be checked. Alright. So after all these things, we have seen the justifications that are given in order to justify the practice of judicial review. Judicial activism. Now we are going to talk about the apprehensions, or you can say the restrictions that must be put on judicial activism, or the apprehensions that must be surrounded the judicial activism. That is by Dr. Upendra Bakshi. So we can say Upendra Bakshi identifies the various concerns that are related to the judicial activism, which he describes as eliciting a range of anxiety among some conscientious justice and all. These apprehensions are as follows. The first is the ideological fear. There are concerns that judicial activism might encroach upon the powers of the legislature, executive, or other independent institutions within the civil society. The fear is that the judiciary could be overstepping its bounds and interfering with the roles assigned to the other branches of the government. Thereafter, the epistemic fear. There is an anxiety about whether judges possess the sufficient expertise in some specialized field, such as economics, science, or technology, or not. Then, the concern is whether they have the requisite knowledge to make informed decisions or complex matter traditionally handled by the expertise in these domains. Alright? Okay. Thereafter, The second thing that he said is the management fears. Like the judiciary faces the fears that are related to the increased workload because of the rising public interest litigation cases. This is the concern that is additional litigation could exacerbate the already substantial backlog of the cases. Thus, it could impact the efficiency and the effectiveness of the judicial system. Okay. Thereafter, the legitimation fears. There is a worry that the judicial orders might issue in the context of the PILs may be disregarded or ignored by the executive branch of the government. That could leading to a potential erosion of the judiciary's authority, and this could undermine the public confidence in the judiciary as a viable democratic recourse. Okay. Thereafter comes the democratic fears. The proliferation of the PILs generally raises the concerns about whether such activism is genuinely nurturing democracy or if it is potentially undermining its future potential under this category. There is a debate about whether the increased judicial involvement might detract from democratic processes and institutions or not. Thereafter comes the biographic fears. There are personal concerns among judges about their legacy and place in the national affairs after the retirement. Judges may worry that the excessive involvement in certain types of litigation could impact how they are remembered and evaluated once they leave the bench as a judge. After this comes the introduction part of the judicial restraint. So we can say the judicial restraint is a principle whereby the courts limit their own power and generally avoid intervening in the functions of the legislative and executive branches of the government. This approach is aimed at maintaining a balance among the three branches of the government, and these three branches are judiciary, executive, and the legislative. Here you could see them also. If we talk about the key aspects of the judicial restraint, then the key aspects generally included. First is upholding the established laws. The courts respect and enforce the laws that are created by the legislation rather than they substituting their own judgment over them. Thereafter, they respecting the separation of powers. By refraining from overstepping their bounds, the judiciary generally maintains the distinct roles and the responsibility of each governmental branch also. Thereafter, allowing the legislative and executive functions. The courts must avoid encroaching on the areas where the legislature and the executive have their own mandates. Like we can say at the fourth, honoring the democratic principles. Judicial restraint upholds the democratic process by leaving policy decisions to elected representatives and policymakers. In a broader sense, we could say, like the judicial restraint is just an opposite of what is a judicial activism. Okay, like judicial activism allows the court to interfere in the matters of executive and the legislature, while the judicial restraint advocates that the court must stick to their own value of judgments and all, and should not interfere into the matters of executive and the legislature. If we talk about this, we could have the trends in the judicial restraint. The first is SR Bommai versus the Union of India, 1994. This case is often cited as an example of judicial restraint. Like we can say, basically the Supreme Court held that certain matters such as those which involving the Article 356, which deals with the imposition of precedence rule in the state. These are political questions and thus not subject to some judicial review. The court emphasized that applying the judicial norms to political issues would be an overreach, and therefore it could choose to avoid the intervention in this political domain. Okay. Thereafter, Almitra H. Patel versus Union of India, 1998. In this case, Supreme Court displayed a restraint by refusing to issue directions to the Municipal Corporation of Delhi regarding the management of cleanliness and all. Basically, the court ruled out that it could not dictate some specific responsibilities or operational details to the corporation, as its role was limited to ensure that the legal duties were assigned and followed as per the law. This decision highlighted the court's reluctance to delve into some administrative matters, reinforcing the principle of judicial restraint. After this, so far we have seen the judicial activism, justification of this and all. Thereafter, we have seen the apprehensions surrounding the judicial activism, and then we have a discussion over the judicial restraint. Now, what we are going to see? We are going to see the judicial overreach. So, judicial overreach occurs when the judiciary extends its authority beyond its traditional boundaries. This is often as a response to the legislative or executive inaction or inadequacy. This phenomenon arises when the courts got engaged in the activities that were traditionally fall within the domain of the legislature or the executive. This impacting the balance of power among the branches of the government and others. If we talk about the impact of judicial overreach, first is threat to the separation of powers, erosion of constitutional balance. Judicial overreach can undermine the doctrine of separation of powers, which is foundational to the Constitution. When the judiciary steps into the areas typically reserved for the legislature or the executive, it disrupts the intended balance and independence of each branch. This encroachment can even diminish the distinct roles of each governmental branch and could create a lack of harmony between them. After this, the second one is the perception of legislative inaction. Perception we are talking about. We can say when the judiciary generally intervenes excessively due to the perceived legislative or some executive failures. Generally, it could create an impression of inaction or incompetence within the elected branches of the government. Alright? And this may lead to a public perception that the legislature is generally not able to fulfill its duties. Further, this could strain the relationship between the judiciary and other governmental branches of it. Got it? Thereafter, third point, lack of specialized knowledge. Expertise and harm. Like, there are the certain issues such as those which are related to the environmental policies, ethical consideration, or even the political matters. And these matters, as we know, require the specialized knowledge and the expertise. If the judiciary generally intervenes in these areas without having some adequate expertise, it risks undermining the input of qualified experts and could potentially make decisions that are harmful or counterproductive. Thereafter, the erosion of democratic faith, impact on democracy. The excessive judicial intervention can signal a disregard for principle of elected representation. If the judiciary takes on roles that are typically the purview of elected officials, it may erode public confidence in democratic institutions and processes also. This could lead to diminish the faith in the democratic system and its capacity to address the issues through some elected representatives. Okay. Thereafter, the public interest litigation or the PIL, the introduction part of it. So we can say the PIL generally emerged and evolved in the United States of America during the 1960s time. Its primary goal was to offer some legal representation to the groups and interests that were previously underrepresented or get ignored. This approach acknowledged that the conventional legal market often fails to serve the significant segment of the population, including the marginalized groups such as the group of poor and the environmental advocates, consumers, racial or ethnic minorities. In India, the PIL further developed as a result of Supreme Court's judicial activism, and that was officially beginning in 1980s. Or we can say early 1980s. Alright. Like key figures in introducing and shaping the PIL India were Justice V.R. Krishna Iyer and Justice P.N. Bhagwati. PIL also referred to by various names, including SAL, the Social Action Litigation, SIL, the Social Interest Litigation, and Class Action Litigation, CAL. Alright. Thereafter, if we talk about the public interest litigation in India, the arrival in India. So we can say the public interest litigation in India represents a significant shift from the traditional legal principle of locus standi. It means traditionally on the individuals that are directly affected by a legal issue, those personal rights were infringed, those only could approach the court for remedies. In PIL, this relaxes the rule to allow the broader participation. Like we can say, under PIL, any public spirited individual or social organization could approach the court to advocate for the rights of individual or rights of group who could not themselves seek legal relief due to the poverty, ignorance, or social or economic disadvantages. Essentially, PIL enables any concerned citizen with a sufficient interest to bring issues to court on behalf of others, aiming to address the collective grievances. Okay. Thereafter, we can say the Supreme Court has described the PIL as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of the community have a pecuniary interest or some interest by their legal rights or liabilities are affected. The core purposes of PIL are crucial for upholding the justice and accelerating the goals which they include. Like, first goal is upholding the rule of law. This is to ensure that the laws are enforced fairly and consistently. Second is enhancing access to the justice. It means providing the legal remedies to socially and economically disadvantaged groups who might otherwise be unable to seek justice further. Thereafter, realizing the fundamental rights, ensuring that the fundamental rights are meaningfully protected and realized for all citizens. Features, if we talk about legal aid, PIL serve as a strategic component of the legal aid movement aimed at making justice accessible to the impoverished and marginalized populations who generally got overlooked. Thereafter, distinct nature of litigation. Unlike the traditional adversarial litigation, which involves dispute between two parties, where one seeks release and other resists, the PIL operates differently. Focus on addressing the broader issues that are affecting the public rather than some individual conflicts. Promotion of public interest. PIL is not about resolving the personal dispute between individuals. Instead, generally, it seeks to advance and protect the public interest, addressing the systematic issues and advocating for the collective welfare. Addressing systematic violations. PIL ensures that the violation of constitutional and the legal rights affecting the large groups of people, particularly those who are poor, getting ignored, and socially disadvantaged, and are generally not recognized and rectified. Thereafter, the collaborative effort. PIL represents a cooperative endeavor involving the petitioner, state or public authorities, and the court. The goal is to enforce the constitutional and legal rights for vulnerable sections of the society and promote the social justice. Thereafter, redressing the public injuries. PIL generally aims to address the public grievances, enforce the public duties, and protect the collective rights and uphold the public interest rather than focus solely on some individual rights. Assertive judicial role. In PIL, the court adopts a more proactive roles compared to the traditional litigation, actively engage in determining actions and solutions rather than merely passively adjudicated. Flexible but judicial. PIL allows for procedural flexibility but not common in traditional litigation. All procedures must still adhere to judicial standards and principle of judicial proceedings. Focus on public welfare. Unlike traditional dispute resolution, PIL does not focus on advocating individual rights but on addressing issues that affect the broader public. Thereafter, if we talk about scope, in 1988, the Supreme Court established the guidelines for considering letters or petition as a PIL. These guidelines have been updated between the 1993 and 2003. According to these guidelines, the petitions will be generally be entertainment if they fall into the following categories of bonded labor, cases involving bonded labor practices, neglected children, issues concerning the neglect and exploitation of children, labor rights, complaint related to the non-payment of minimum wages, exploitation of casual workers, and violation of labor laws, excluding the individual cases. Then the prison condition petitions from inmates addressing the harassment, premature release requests, release after serving 14 years, death in custody, transfer, release on personal bond, or claims for a speedy trial as a fundamental right. Police misconduct, complaints about the police refusal to register cases, police harassment, or deaths in the police custody. Women rights, cases that are related to the atrocities against women, including the harassment of brides, bride burning, rape, murder, kidnapping, etc. Thereafter, discrimination against marginalized community, complaint of harassment or torture of individuals from scheduled castes, scheduled tribes, economically backward classes by fellow villagers or the police. Then environment and public health issues, riot victims, and family pensions. In which cases the PIL could not be addressing, like the landlord and tenant disputes, service and the pension matters, general complaints against the government departments, educational admissions, and expedited hearing request. If we talk about the principles of PIL, the first is standing for disadvantaged individuals. Under Article 32 and Article 226 of the Constitution, the court can pertain petitions from any concerned individual organization advocating for their disadvantaged groups who are unable to approach the court by themselves. Court is obligated to safeguard the fundamental rights of these groups and mandate the state to fulfill their constitutional obligation. Second is relaxed procedure for public issues. When dealing with the matters of public signification, publicly or particularly involving the fundamental rights of a large segment of population or constitutional duties of state, the court may consider the letters or telegrams also as a PIL. Intervention in case of the widespread justice. Court is empowered to invoke Article 14 and 21 of Constitution along with relevant international human rights convention whenever there is a widespread injustice affecting the numerous people, ensuring a reasonable, fair and trial. Relaxation of locus standi. Principle of locus standi is relaxed in PIL. Cases to enable the court to address grievances on behalf of poor, uneducated or disabled individuals who are unable to assess their constitutional and legal rights on their own. Prima facie violation. Court is initially satisfied that there has been a violation of constitutional rights affecting a disadvantaged group. It may proceed with the petition without allowing the state or government to consider the petition's maintainability. Applicability of procedural law. While procedural law applies to the PIL cases, the principle of res judicata or similar doctrines will depend on the species of case and its circumstances. Exclusion of private dispute. PIL not includes the private dispute. Broader public interest consideration. The PIL generally considers the broader public interest rather than situating or individual assets. Use of commission. In special cases, the court may appoint commission or other bodies to investigate allegations and gather facts. May also oversee the management of public institutions during such investigation. Respect for policy decisions. The court will avoid devolving into policy matters and will exercise the caution to ensure it does not exceed its jurisdiction while protecting the individual rights. Thereafter, the limits of judicial review. The court generally refrains from stepping beyond established areas of judicial review. High Court have the power to ensure justice but do not possess the broad authority that was provided under Article 142 of the Constitution. Thereafter, the constitutional challenges. High Courts typically not forum for the PILs challenging the constitutionality or validity of the statutes or the statutory laws. This could be only taken over by the Supreme Court. If we talk about the guidelines that have been set by the Supreme Court, first is encourage genuine PILs. Court should promote sincere and legitimate PILs while actively discouraging those that were driven by extraneous motive. Formulate a clear rule so that the petitioner could be aware about the things. Verify the petitioner's credentials. So it could be for the advocation of public interest. Thereafter, confirm petition validity. The court should be satisfied with the accuracy and the truthfulness of the petition's content before the proceeding. Thereafter, assess the public interest. Courts must ensure that the petition addresses a significant public interest before it is admitted. Prioritize the important cases. Petition involving the serious public interest and urgency should be prioritized over others. Ensure the genuine intent of the petitioner and discourage the frivolous petitions. Okay. So students, here we have finished the topic. Now just a summary part. So basically we have seen the justification of judicial activism. We have seen the additional situations for the judicial intervention. We have seen the trends and concerns in the judicial activism. We have seen the concerns with the judicial activism. We have seen the judicial restraint. We have seen the examples of this. We have seen the impact of this. We have seen the public interest litigation, origin and development part of this. Key features we have seen. These are the key features. Primary guidelines of the PIL we have seen. Okay, like this and all. Thereafter, categories that are not entertained under the PIL we have seen. Principles of handling PILs we have seen. Okay, and guidelines for admitting the genuine PILs we have seen. So here we have finished the topic. Please revise the facts and figures that all we have discussed in this lecture. Be ready for the next lecture. With this note, let's end this lecture and thank you.